Well, you might ask, what is community property in Arizona? Well, community property in Arizona is property acquired or obtained during the marriage, from the date of the marriage, all the way up until the date of service of the divorce petition. But, you know, people generally think of cars and houses and retirement benefits and bank accounts, but there are also other things that can be divided as well. I've litigated cases where we were disputing whether an embryo or an egg is property. And also things such as goodwill in a dental practice or in a legal practice is also considered community property potentially. So it's always wise to seek out the services of a competent and qualified family lawyer so that you can identify all of those items that might be deemed to be community property in the state of Arizona. The law in Arizona requires that a couple's community property be divided fairly and equitably. Now, generally that's equally divided, but not always. Again, it's equitably divided. So what that can mean is creative lawyers get together and come up with solutions to make that happen. For instance, if husband is awarded the community residence, he could perhaps pay wife her 1/2 interest in that equity in other forms. It could be she takes more of his retirement benefits, she gets more of the vehicles, more of the bank accounts, those types of things. On the other hand, though, if you leave it up to a judge, the court can be a little bit more rigid, and I like to call it the guillotine. Sometimes they just kind of chop everything in half, and oftentimes I think that if they could cut a couch in half and give half to each party, they would.